welcome back to Law&Crime. We pivot now to Florida for the suitcase murder trial against Sarah Boone. The defendant is accused of second-degree murder for the death of her boyfriend, Jorge Torres. The 42-year-old died on February 24th, 2020, and he was found in a blue suitcase at their home. The defendant claimed she was playing a game of hide-and-seek with Torres after the two were drinking alcohol. She went upstairs and passed out. The next day, she found him inside the suitcase and unresponsive. Boone's ex-husband told her to call 911. Ultimately, emergency responders confirmed the victim was dead. Boone faces life in prison if she's found guilty. Now, earlier this month, the judge ruled that Boone must represent herself in the trial after cycling through 8 attorneys. They requested to withdraw from her case for various reasons due to conflict, irreconcilable or ethical differences. Now, on Friday, Boone wrote a lengthy handwritten letter to the judge saying, quote, "It is my belief and from your order that actions speak louder than words. The court is sabotaging me, forcing me, pressuring me, setting me up for failure. If any of the prior attorneys would have included or cared or collaborated during their time of representation." She goes on to say, quote, "I am defending myself against your inaccurate libelous. I can write letters too. Order, please would you post my included in documents in your break room, wherever you think it may be seen and understood, unlike me in your courtroom." Lastly, she writes, quote, "Remember, please judge Koenig fair, neutral, impartial, and must always be." All right, I didn't really catch all of that. Some of it is a little bit confusing, but still with me, I have Bridget Williams and Joe Richardson. You know what, Joe, one of the things I think about here is she cycled through 8 attorneys. She's a little bit all over the place. She's writing to the judge. What is she trying to accomplish here?
Well, other than the part of leaving your boyfriend in the suitcase, I know people like this. Okay, they know more than the attorneys. They cycle through them, and she's done it so much that the judge has basically said, "You're not going to have any more attorneys. You're going to represent yourself." Okay, so she's trying to run out the clock. She's not thinking clearly, but she wasn't thinking clearly when she basically killed her boyfriend either. I think that they've got fairly good evidence in the way the phone call, where she's basically talking to him and saying why she locked him in there. And so she's trying to run out the clock, but she's not trying to do anything reasonable where we can answer the question and all of us can then say, "Oh yeah, okay, I understand that." She's just not thinking clearly, and she has a different definition of representation than the rest of us.
Exactly. And one of the things, Bridget, I think she's absolutely accomplishing here, having gone through 8 attorneys, I guess she's going to represent herself now, but she really has stalled this case. At some point, it's got to start, though, correct?
That is correct. We can't continue to just wait around for you to get an attorney that fits for you. Out of 8 attorneys, everyone cannot have been, not doing right by you. There's a common denominator here, and that's you. And so with that being said, it is just where I feel like she's really just stalling. Whenever an attorney puts up a motion to withdraw for irreconcilable differences, it's because the defendant is either not listening, doesn't want to listen to the advice of the attorney. Now we're at an impasse. The defendant is just deciding that they're going to do whatever it is that they want to do without defense counsel's advice. So if that's the case, then you're better off representing yourself without their attorney. So the attorney decides that they're going to withdraw from the case. And so now no one is moving forward with being her counsel. So she's really at this place where she has to move forward because the court's not going to continue to just wait along for you to hire counsel that's a good fit. You need to move forward with this.
Exactly. I mean, time is a wasting here, and anytime justice is delayed, it's denied. Joe, she may have to represent herself, but can she get someone who can help her if she has any questions? You think the judge is going to give her someone who can assist her if she's representing herself?
That actually would be a good middle ground if that was available. The judge could say, yeah, if you want to consult with someone, you can, but you allow it in a way that doesn't allow her to then turn around and say, oh, I got bad consultation. And so if her plan is to stall and to run out the clock, it has to be done in a way, what the judge allows has to be done in a way that still keeps the onus on her and keeps the case moving forward. So theoretically that can happen. We've seen that happen in different jurisdictions where someone is representing themselves, but they can still consult with someone that either sits there or, however that goes. But it's going to have to happen in a way that keeps the case moving forward.
Exactly. And one of the issues, obviously, is time and money and resources to determine whether or not they can actually help her out. Bridget, if she is representing herself, she's going to have to question witnesses. And she's going to have to decide if she wants to get on the stand. How would that work out? Have you seen a situation where someone representing themselves pro se wants to testify?
I have seen situations like that, and it just always doesn't always play out in their best interest. Whenever someone who's pro se that hasn't gone to law school, hasn't practiced, especially litigation, it is an art to it. It is a purpose for, it's a reason why people practice litigation. They study it and they know the rules of evidence. Whenever someone decides that they're going to, move forward and say, well, I'm going to be a witness. Well, are you familiar with the rules of evidence and how to present that evidence in your statements and the manner of which you want to bring evidence into this particular trial? And so without that knowledge base, then a lot of evidence that you want to get in will not be coming in. And so that's where you kind of shoot yourself in the foot, because you think, well, this is pertinent information, it needs to go forward. But if you don't know how to get that into evidence, then it's not coming in.
Exactly. And, Joe, one of the things she's going to have to quickly learn how to do is cross-examination. And there should be some sort of guidelines for her dealing with, hearsay evidence, how you get it in. I mean, yeah, I think you're right, Bridget. A lot isn't going to come in if she doesn't know what she's doing, but there has to be some kind of guidance, right?
There does have to be some kind of guidance. And here's what's going to be interesting. This is where the judge really proves their own mettle, in that how do you deal with someone who's so difficult so that you can still move the case forward, be fair, probably to a fault and over and above, but still make sure that the case moves forward and that there's no appealable issues. So there's going to have to be, again, some balance stricken where there's some direction about, well, here's what you have to do. This objection is being sustained. You're going to have to do X or Y or Z from a guideline standpoint so that it continues to go on. At what point do you shut it off? How long do you let it go? She may be trying to you might have to put a time frame on it, right? After this amount of time, we're not going to allow for any more questions, et cetera. You can't ask outside the bounds of what has happened on direct, et cetera, et cetera, et cetera. But it makes it very, very hard for a judge when you're trying to keep people that don't know the rules going by the rules.
Exactly. Yeah. Bridget, one of the things that's really interesting about this case is if she represents herself, she's going to have to do an opening statement. She's going to have to do a closing argument. But that does give her an opportunity to actually talk to that jury, correct?
It does give her an opportunity to do that. But even in opening statements and closing arguments, we still have to do it within certain parameters. Again, we go back to rules of evidence. And so whenever a person is just not familiar with that and you haven't studied it and you haven't practiced it, that doesn't give you just free reign to talk about any and everything that you decide you want to talk about. And so that's the problem, generally what we see whenever there's somebody that represents themselves that's not a lawyer. Even people who are lawyers that represent themselves in their own cases, we don't highly recommend that because then you're emotionally attached to the case. So whenever a person is representing themselves in their pro se and not a lawyer, then again, we don't have to give you the rules of evidence. It's your job to be familiar with it because you made this decision to represent yourself.
Exactly. Joe, she did ask when she wrote that letter to the judge to put up a note in the courtroom somewhere. Maybe we can show that note again. It says, inmate seeks attorney looking for a prosperous challenge, ready for your close-up on national television. Qualifications must include being trustworthy, honest, passion-driven, open-minded. I mean, it's a very interesting request. Do you think the judge will post that And it seems as though the judge has said, no, we're moving on. But I've not seen that type of request before. Have you?
Neither have I, and obviously you can tell here that something in the middle's not white, right? The judge is not going to allow that. That's not going to just be able to get posted anywhere, I don't think. And so, this is, again, what it is that you're dealing with. The judge is going to have to spend a lot of time instructing the jury about things to ignore that were said. I can see her talking about her larger gripes in her opening statement. And I've gone through eight lawyers and this and that. And, I'm set up to fail. I mean, she's going to sound in a way where the judge is going to have to really level a lot of this off and keep the jury focused. But yeah, I mean, it's really interesting. But any lawyer that she got would never be good enough because she's gone through 8 of them because she doesn't understand the rules. And again, if this is part of running out the clock, she would use everything that she could in order to do so.
Exactly. And I think one of the things the judge will have to do is give an instruction to that jury saying, look, she has the right to represent herself, and that's why you see her here, just to be clear to that jury. All right, we're going to take a break now, but we'll have more to uncover when we return. Stay tuned.